Good afternoon. My name is Barbara Mainhart, and I am the Outreach Coordinator here at the Alpha Center for Divorce Mediation. Today, my guest is Debbie Schneider, who is an attorney-mediator with the Alpha Center. We've been doing some videos on people who are getting divorced later in life, which means that they've probably had a long-term marriage, and so certain assets and other issues have built up. And today's topic is about retirement plans. When approaching divorce and taking a look at what their retirement plans are, there are a number of questions that need to be answered so that there can be an equitable distribution or decision about what you're going to do. So I'm going to ask Debbie to talk to us a little bit about what this is all about and how to walk through this. Thank you very much for joining us, Debbie.
Thank you, Barbara. I'm happy to be here. So the first question really that I would suggest that any divorcing couple or couple contemplating divorce look at is what kind of retirement plans do they actually have. So you mentioned equitable distribution in Pennsylvania. That is the guiding principle about how a marital estate is divided in Pennsylvania. And equitable distribution says that everything that a couple have acquired is considered marital property regardless of whose name is on it. And this is particularly important with retirement accounts, right? So that even if a person had a retirement account when they entered the marriage, the value of that account can be it's not made part of the marital estate, but it becomes marital property when the two parties get married. So the easiest example is if one person has an IRA, for instance, an individual retirement account, and it's worth $50,000 at the time of their marriage, but at the time of their divorce, it's worth $100,000. So the first $50,000 is excluded from the marital estate, but the increase in value is considered marital property. So that's the guiding principle. And then, as I said, I would suggest that any couple facing a divorce or contemplating divorce spend a bit of time figuring out actually what the retirement accounts are. Now, hopefully both people have an understanding of this, but many times couples don't, particularly if one person has been the primary financial decision maker and the other person less so. So
right. So what are the dividing factors? How would you categorize retirement accounts?
Okay, so there's typically two large categories. The first category is defined contribution accounts. And if a defined contribution account is a 401k or a 403b, and a 403b is just a different kind of 401k, and they're usually given to employees who are working for a nonprofit organization.
And are IRAs included in this?
No, IRAs are not included. IRAs
okay.
are a separate kind of retirement account.
Okay.
It's essentially a defined contribution account, but it's a separate category. All right.
Okay.
The other category is what's called defined benefits.
Oh, yeah, I've heard about those.
Right, and those are what I describe as pensions. All right. Now, everybody should understand that these retirement accounts, there's many, many, many different kinds. So in the large subset of defined contribution and defined benefit plans, there's a huge range of what is done by many companies. It's like everything is normal, but it may be particular to that particular company, right?
Mm-hmm.
Functions, right? So we look at the value. The first thing you look at is what is the value of the particular account when two parties come in and commence their divorce, right? So we look at the value. The best thing to do is look at the most recent statement. The defined contribution account is going to have a total at the bottom of it, right? The statement will show a total, and that's basically what the value of the account is on the day that the statement is generated. Defined contribution account is typically a little more complicated. They are monies that have been set aside by a particular company to generate a future stream of income.
Mm-hmm.
So it's a much more imprecise kind of measurement. And typically we recommend at the Alpha Center that parties have their defined benefit plans valued. And that is because it is a future stream of income, not something that you can value easily by just looking at it.
Let me ask you this. With a defined benefit, is it the same thing like prior to marriage versus after marriage?
Well, it's by virtue of marriage, then the rights and responsibilities of each party are going to change. So it may be a defined benefit plan has one value as a single person, but when that person marries, then once there is a secondary piece that belongs to the spouse, then it may have another value. So it's a more complicated retirement asset.
Okay.
And actually, defined benefit plans are done more infrequently in this day and age. It used to be a common kind of retirement plan, but they're very costly for the companies. So you see them done less and less.
It's more like your basic 50s and 60s pension plan sort of thing.
Yes.
So so how does the defined contribution plan, who handles splitting that up?
All right. Well, sometimes the parties can handle it themselves. All right. Now, we look at what the value is, and then we just, in a mediation or in any divorce setting, you just look at the value and what makes the most sense. So if you need to transfer retirement assets between spouses in the divorce, then you need a mechanism to transfer those funds. For many defined contribution plans, you need what's called a qualified domestic relations order or a domestic relations order. The qualified piece is just another definition. So you look at what is necessary, what the value of that is, and what needs to be done specifically within the qualified domestic relations order. As I said, many couples now are able to do them themselves. But you can also hire someone to do them. There's lots of services, third-party services out there now that will do it for you, and many couples to do it that way.
And so does this affect the taxation, like when they're splitting this up? Is there any liability when they're splitting up through a quadro?
The quadro is the mechanism that is created by federal ERISA law, and federal ERISA law governs the distribution and how these retirement plans are how they work, how they're conducted. So if you were to split a defined contribution plan and the person simply withdraws money and gives it to the spouse, you will incur income tax, and depending on the ages of the parties, you will also incur a penalty. Well, the beauty of the quadro or qualified domestic relations order is that there's no tax and no penalty. So the creation of the ERISA law and the creation of the quadro mechanism is what has helped many couples in a divorce, and they're useful tools. We use them all the time in the divorce.
Right. So what happens then, what I'm gathering from you, is that when you use these tools, then you're not, and I have seen this before where people just split it up and give you, there's cash involved. So this allows it to like be distributed into another account without ever coming through that person and getting the cash.
So the quadro can function in many ways, but ideally it's just rolled over into another qualified retirement account. And that's what the quadro does. That's what it creates, is this mechanism. No tax and no penalty. Now, the person who's receiving the quadro also has the opportunity, as a function of the quadro, to take a cash distribution of the funds. And while that cash distribution will be taxed at that person's tax rate, you can escape the penalty. So for many couples, that is a another useful mechanism part of the quadro.
So that is if they actually take the cash.
Correct.
Right. Okay.
That only applies when they take a cash distribution of the money.
Okay. So that sounds like something that, you know, is very important, especially in divorces that are later, like after 50 or so, et cetera, and to make sure that each of them are protected.
Absolutely, absolutely. Now, you can also divide individual retirement accounts or IRAs, but they typically do not require quadros. Most of the time, they do not require a quadro. They can just be split based on a signed property settlement agreement or marital settlement agreement. Again, if you take any of the money any of the funds as cash, there's taxes on it. But if you just roll it into another retirement account, it's not a taxable event. Again, that's a simple process.
Yeah, and that sounds like, you know, it's although it sounds a little bit complicated when you get to the defined benefit, but most people don't really have that today.
They're done more, but then you see them more and more infrequently.
Right, right. So that's a good thing for people to know going into divorce, that they need to find out what they have, what category it is, so that
Correct.
they know, you know, not because and you know, because I'm sure in the past, you know, like if you don't have someone watching over you, you're liable to say, okay, fine, I'll take this, and then come tax time, it's a big surprise.
It often is a big surprise, right?
Yeah, a very sad surprise. So yeah, so thank you so much for that guidance, and I'm hoping that anyone who is looking at this video will at least take the opportunity to say, what do I have, what is it called, and how are we going to split it if we have to, and make good decisions about it.
Right, and that's absolutely correct, Barbara. And the appellate courts in Pennsylvania have stated a preference that people not divide their retirement accounts, but particularly for long-term marriages and those of the more traditional variety, where one person has been the primary breadwinner and the other person is the more dependent spouse. A quadro, or splitting of retirement assets, is an integral part of their divorce. And particularly for those couples over 50, it may be those retirement accounts may very well comprise a big portion of their estate.
Right, as opposed to someone in their 30s or maybe even early 40s, where each of them is building a retirement account. It's a lot different than 20, 30 years or 40 years of building this, because it's really a joint retirement account in a sense.
Right, exactly. Oh, it absolutely is when it comes to divorce. Yeah, their retirement accounts are individual accounts, but when it comes to divorce, they're joint property.
And so what you're saying is that people who are maybe younger or earlier in their careers might just make the decision, you keep yours, I'll keep mine, and not worry about it.
Oh, absolutely.
But for other people where it is part of their financial assets and their financial health, it may be important to make sure that you take a look at this and make good decisions.
Oh, that's absolutely right. I mean, it's an important piece of this. And so I recommend everybody just, as I said, when they're contemplating divorce, it's a good idea to do some research and figure out what you're looking at and think about how it might fit into the whole picture.
Right, and if they have not done that, then the Alpha Center, when you go through your mediation, will make sure that you understand what you have and what the possibilities are as part of our program.
Absolutely, and it often comes as a very, very welcome information for those parties, particularly the more dependent spouse, who may not have as much in their own name. For them to hear from the attorney-mediator in our mediation program that, oh, you're entitled to this. This is the law, and it's perfectly okay for this asset to be split between the two of you.
Wonderful, wonderful. Debbie, thank you so much for your insights into this, and you know, and the guidance that you have given us today. If anyone would like to see or read more about this, you can go to our website, alpha-divorce.com, where you can see this video and the blog that Debbie has written for giving you more and more information. If you have any questions, call us 800-310-9085, and we will make sure that your questions are answered. And thank you so much.
Bye, Barbara.